Okay, kicking off our afternoon session, we have Michelle Hill, who's a partner at Dentons Kensington Swan. Michelle has particular expertise in commercial leasing and is a regular columnist in the New Zealand Law Society's The Property Lawyer and writes on a range of commercial leasing topics. Michelle's on the Property Transactions Committee of the New Zealand Law Society and is on a New Zealand Law Society working group assisting the Ministry of Justice with COVID-19 related commercial leasing issues. Here to present on generating mutually beneficial outcomes for parties in changing environments, please welcome Michelle Hill.
Thanks, Ben, and good afternoon, everyone. I would like to say it's great to see you. Obviously, I can't this time, but I do hope that you're well and that you have been successfully navigating this very challenging year. I was reading a Law Society seminar paper last week on commercial leases and disasters. How robust is your lease? And I then looked at the date of the seminar and it was the 13th of February 2020. Well, little did they know what lay ahead and that this year would cause every commercial tenancy to ask that question, not only here in New Zealand, but commercial tenancies right around the globe. So my topic is generating mutually beneficial outcomes for parties in changing environments. And the synopsis to my session is that I'll be delving into creating a fair approach towards negotiations through quantifiable measurements to enable mutually beneficial outcomes for landlords and leaseholders. Breaking that down, I'm going to cover three main things. I'm going to look at our now famous no access and emergency clause, and I'll consider, what's worked with it and what hasn't. I'll then be asking the question, should the parties adopt a fair approach to negotiations? And then finally, I'll give you some of my ideas as to how to achieve mutually beneficial outcomes through quantifiable measurements. First though, let's take a look at the last couple of decades and our changing environments and how our commercial leases have evolved so far. I'll also look at the New Zealand commercial leasing response to COVID when contrasted with other countries around the globe. So the only constant is change. Our environment, our building practices, our laws, certain events are always changing. And so you and I, participants in the commercial property industry, we really are dealing with a constantly evolving situation. There are certain key events during the course of my career that have really stood out. In 1998, we had the Auckland power crisis, where we had a 5-week-long power outage in central Auckland. And at that time, commercial leases didn't have provisions dealing with the situation. So after the power crisis, many commercial leases were amended to clarify that landlords have no liability for any cessation of supply of electricity or other consumables. Then in the 2000s, we had the Leaky building syndrome, with liability for water tightness coming to the fore. And although most leases required landlords and still require landlords to keep and maintain the building and to keep it weatherproof, this wasn't the same thing as watertight. And so many leases were again amended to require the landlord to keep the building watertight and to make it clear that tenants are not liable for inherent defects. We then had the devastating and the catastrophic earthquakes in Christchurch in 2011. And that again revealed inadequacies with our standard lease documentation. They just didn't accommodate the scenario that the leased premises themselves may not have been damaged or destroyed, but the tenant couldn't access the premises because they were in the cordoned off red zone in central Christchurch. So after that, there was an overwhelming flood of requests to the Law Society that it amend the ADLS lease to cater for the concern that tenants that couldn't access their premises shouldn't be held to the obligation to continue to pay full rent. So then we saw in 2012 the new revision of the ADLS lease with this now famous clause 27.5, no access and emergency clause. And that was drafted into the ADLS lease in direct response to the Christchurch earthquake situation. There were also other changes to the ADLS lease at that time, which included removal of the improvements rent and also other provisions to make it clear that if a landlord had to upgrade the seismic performance of a building, then that was to the landlord's account and that wasn't the tenant's responsibility. Then in 2016, we had the extent and the health risk of asbestos came to the fore with the introduction of the Health and Safety at Work asbestos regulations in 2016. And this exposed that tenants have very limited grounds of recourse against their landlords with regards to asbestos unless it's expressly written into their lease documentation. Then in 2017, the Grenfell disaster in London put a further focus on hazardous and deleterious building materials, which again, as with asbestos, highlighted that provisions in standard lease documentation impose limited obligations on landlords unless expressly written into their lease arrangements. And that brings us to 2020. What a year. I have to say, professionally, it's been very stimulating. There was a period there where it seemed like daily we were getting changes in legislation and policy, government announcements, not to mention the changing status of alert levels. But it was clause 27.5 that very much has taken the spotlight and has been under the microscope ever since. What is different about this pandemic to all of those other events that have crafted the changes to the leases over the last couple of decades is that, surprising to many, and particularly to our Australian cousins, our standard, most widely formed lease does already provide for a pandemic situation. And this is the clause 27.5. I would mention that there is, of course, a provision in the Property Council lease that deals with a no access in the case of emergency. But as Jack Quillen mentioned earlier, it doesn't apply where the landlord is unable to access insurance, which has been the case for the pandemic. Now, the government did announce in June that it was going to introduce a mandatory rent abatement akin to the no access and emergency clause across all leases. So there was hope there for tenants that didn't have the ADLS lease that they were going to be entitled by law to an abatement of rent. And the qualifying leases were going to be, they had to be New Zealand-based tenants, they had to be have staff 20 or fewer. But the proposal didn't win the support of the government's coalition partner, New Zealand First, and so that proposal was dead in the water by July, and I can be pretty certain it's not going to come back on the table either. Having said that, the government has announced that it is proceeding with a subsidy scheme where the government will subsidise arbitration of rent disputes, and that scheme should be up and running by the end of this month. So although we've had no government intervention here in New Zealand regarding mandatory rent abatements, we really do lead the way internationally insofar as our most commonly used lease already contractually provides a right to an abatement of rent in a pandemic situation. But let's just take a look at what some of the other countries have been doing. You know, many, I think, would say the majority of countries, at least those within the Dentons network, have some form of government intervention, particularly a prohibition against landlords taking enforcement action against tenants due to COVID, but also providing some form of financial support in the way of tax breaks and financial assistance. However, as mentioned, none appear to have provisions in their standard leases that respond to the pandemic situation. In Australia, the federal government released a mandatory code of conduct, which was in effect after the 3rd of April. And that requires a rent and rate reductions and deferred payments for the duration of the state of emergency, plus a reasonable recovery period thereafter. And the code sets out 14 good faith leasing principles for negotiations between landlords and tenants experiencing financial stress or hardship as a direct result of COVID. There are eligibility requirements. The tenant has to be a small to medium enterprise with an annual turnover of up to 50 million Australian, and they also need to be an eligible business for the government job seeker program. The code also requires that the parties must negotiate in good faith. So this is going a step further than our government's plea that parties please be kind. And the code really does focus on the common goal of preserving the status quo that existed between landlord and tenant pre-COVID. And where landlords and tenants can't reach agreement on the temporary arrangements as a result of the pandemic, either the landlord or the tenant may refer the matter to the relevant state or territory dispute resolution process for a binding mediation. So some of the leasing principles in the Code of Conduct are that, again, landlords must not terminate a lease for non-payment of rent during the pandemic. Landlords must give rent waivers, and the guidance there is a 50% waiver of rent. Also, landlords must also offer tenants a deferral of rent for 100% proportionately to the reduction of the tenant's trade, and then the tenant is required to repay that deferred rent over a 24-month period. Also, landlords must not draw on the tenant's security, and tenants are to be entitled to extend their lease out for an equivalent period of the emergency period. Then going across to Canada. Canada has a program that provides forgivable loans to qualifying commercial property owners to cover 50% of 3 monthly rent payments that are payable by eligible small business tenants that are experiencing financial hardship. So again, the small business tenants that are eligible. And the loans will be forgiven if the landlord agrees to reduce the eligible small business tenant's rent by at least 75% for the 3 corresponding months under a rent forgiveness agreement. So there, the impacted small business tenants are those paying less than $50,000 per month on their rent and who have temporarily ceased operations or have experienced at least a 70% drop in revenue when compared to pre-COVID revenue. In China, mainland China, there are certain exemptions for certain taxes, and in addition, financial support measures were introduced which proposed, amongst other things, to defer or reduce rents and interest on financial leasing businesses. Looking at France now, they have a mediation mission on commercial rents, and this was launched and also led to the establishment of a charter to help landlords and tenants find a balance regarding the payment of rents. In Russia, at the federal level, all tenants are entitled to request a rent reduction for the time the leased premises could not be used due to the state of high alert. And there are tenants operating in certain industries such as transportation, recreation, tourism, hospitality, conference organising, consumer services and non-retail. So tenants operating in those services are also entitled, in addition to a rent reduction, to claim a deferral of 100% of rent during the state of high alert. And after the end of state of high alert and until the 1st of October this year, 50% of their rent shall be deferred. The Spanish government has approved a moratorium on the payment of rent in favour of certain commercial tenants due to financial incapacity, provided that several requirements are met. And these measures are aimed at the reduction of operational costs for self-employed individuals and, again, SMEs. In the UK, landlords are prevented by law from evicting tenants for the non-payment of rent under the COVID legislation, and also they have industry voluntary rent-free periods. In the States, well, to date, there's no special rent abatement relief at federal or state level for commercial tenants who have been impacted by COVID, although some states have implemented a moratorium on loan payments, evictions, and foreclosures. So as you can see, there's quite a range of measures and of course, there's also many countries that have not implemented any measures at all. So here in New Zealand, those tenants on the 6th edition ADLS lease have been somewhat fortunate that they have had a contractual right to an abatement. But for many, unfortunately, the clause has actually only caused more costs and grief as they've entered into, negotiations and disputes with their landlords as to the operation of the clause. So now let's move and look a little bit more closely at this clause 27.5. There are three key limbs to the clause. There has to be an emergency. There has to be an inability to gain access to the premises, and there has to be an inability to operate fully from them. You know, I think that there really was great foresight on the part of the ADLS drafting committee in 2011 and 2012. Although the clause was drafted in response to the Christchurch earthquakes, the definition of emergency was defined very broadly to extend to not only physical emergencies such as the Christchurch earthquake, but also to civil emergencies. And hence it specifically refers to epidemics, which of course implicitly includes a pandemic. And so too the reasons for inability to access the premises. They were broadly described to, as you can see there in A, B and C in the clause, to include not only a physical barrier, which the red cordon-off zone in central Christchurch created, but also a non-physical barrier on access, a non-physical restriction on access, such as has been imposed by a competent authority. The Health Act order, which was made closing all commercial premises, which was the initial level 4 lockdown on the 26th of March, was one such restriction by a competent authority, and therefore the clause is certainly triggered. The third limb is that the tenant is only entitled to relief if they can't access the premises to fully conduct their business. As Jacqueline mentioned earlier, this is something different from the permitted use of the lease, which is often broadly defined. So we are talking about the specific business that that tenant is operating from those premises. If they can access their premises and could do so even during the level 4 alert level to fully conduct their business, then the no access and emergency clause wouldn't apply. And examples here, of course, were the supermarkets and the chemists that were able to remain open and fully conduct their businesses even during the level 4 alert period. Other essential businesses may also be excluded from the clause, but only where the premises were necessary for the performance of the essential business. So here it's necessary to really look at the wording of the Health Act order to determine whether there was a legal obligation on the tenant to close. And I know there's been a lot of talk about essential businesses and that they're excluded, but the wording of the Health Act order is that it's only essential businesses that require the premises in order to perform their essential business. So in other words, those essential businesses that could still operate their business remotely were still required pursuant to the Health Act order to close their business, close the premises. There are other tenants, however, that have been able to access their premises, but only to perform part of their business, such as those businesses for whom an essential business is only part of their business. So an example here is the large hardware stores, Mitre 10, Bunnings. They had to close to the general public, but they were able to continue to remain open for the purposes of the supply chain to provide and supply essential businesses. Therefore, those types of businesses would still come within the ambit of clause 27.5. And clearly businesses that have had to close down completely during the level 4 come within the clause. Those businesses are with the likes of the retail, hospitality, gyms, beauty salons, etc. So the fact that this clause provides relief where the tenant is unable to access the premises to operate fully means that the abatement of rent is available as we have moved up and down the alert levels, until such point as the tenant has been able to get back into the premises to once again operate their business fully. An example is the fast food restaurants. When we moved to level 3, I know we were all over the moon that we could finally get our drive-through takeaways. But those types of businesses, although they were able to open up part of the business, they still had to have the restaurants closed. So they would have been continued to be entitled to an abatement of rent until such time as the restaurant was able to open and they could once again fully conduct their business. So if a tenant can fully operate, then the abatement stops. And this will be the case notwithstanding that business levels have dropped. And an example here is a travel agency. If their lease was on the 6th edition ADLS lease, then their entitlement to an abatement would have stopped when they could once again reopen their premises. And there's no concessions provided in the ADLS lease for the fact that they no longer had a product to sell. So I guess the clause 27.5 is very different from the, even let's looking at the Australian situation with their code of conduct, which provides for that pressure relief for a tenant during the lockdown period, but also for a recovery period thereafter. So although the clause was drafted widely and a pandemic was contemplated as an emergency, the ADLS made a statement in April saying that actually, it was probably not ever contemplated that we would have, that the clause would have operated in the nationwide lockdown situation that we have had. Clause 27.5 was in response to the Christchurch earthquakes, and they were thinking about a smaller geographical area and not what we have had this year, which has effectively been New Zealand has, actually the world, has been in a red cordon off zone. Further, although the no access in emergency clause has been in the ADLS for lease for, 7.5 years, it's never been interpreted by the courts. And it's certainly never been through a pandemic. And because the pandemic is unprecedented, clause 27.5 has really taken the centre stage this year and become the focus of much discussion and debate. In particular, the vexed question, what is a fair proportion for the rent and outgoings to abate? I think a pandemic is the only type of emergency when looking at all of the types of emergency that come within the clause for which insurance doesn't pay out. The question as to what is a fair proportion would not be so critical if the parties knew that it was the insurance company that was picking up the tab for the loss of rent or the business interruption. In the case of COVID, however, the loss is coming out of the landlords and the tenants' pockets. So it really has been a critical question. There was some suggestion that a declaratory judgment be obtained from the courts to give us some guidance as to how to interpret a fair proportion. But this would have been an expensive exercise and no organisation put their hand up to obtain this. Instead, the New Zealand Law Society provided some guidance as to some factors that may be considered, but this is not law, it's just guidance. So some of the factors that were suggested was that what is fair will depend on the individual circumstances. A fair proportion needs to be fair when looking at both the landlord's and the tenant's circumstances. You should also look at the extent to which the tenant is using the premises for some other non-people purpose. For example, is the tenant using part of the premises for storage? Is the tenant able to conduct their business remotely? Also taking into account the tenant's use of the servers and the IT infrastructure that was still sitting in the premises. The Law Society also suggested that the landlord's costs in holding and managing the property should be taken into account. What is the level of the landlord's mortgage? Are there any other costs that the landlord is having to incur, including ground rent? It was also suggested that a fair proportion may, of course, differ between the rent and the outgoings. So we've often seen landlords and tenants agreeing to an abatement and a reduction of the rent whilst still paying full outgoings. So as you can see, there's no one size fits all here. Each lease and business needs to be considered, and there may be many permutations. For example, where a tenant is in a no business situation, but they do utilise the premises for a non-people purpose, such as the storage and warehousing, then they may be liable for the rent based on the portion to which the premises is still being used for that purpose. Further, the no access and emergency clause is concerned with the tenant's ability to conduct their business. So if they can't fully conduct their business, then the clause comes into play. But if they can't access the premises to fully conduct their business, but can still fully conduct it elsewhere, then this is something that should be taken into account. So moving on to the question, should the parties be adopting a fair approach towards negotiations? A fair proportion to which the rent is to abate does not necessarily require the parties to take a fair approach towards negotiations. And indeed, there have been many examples of both parties not adopting a fair approach. From the tenants who have point blank refused to pay rent, notwithstanding they have no right to an abatement of rent, and those landlords who have offered an abatement, notwithstanding they're under no legal obligation to do so. However, I have seen the majority of parties have adopted a common sense, pragmatic view, a pragmatic way towards dealing with the rent abatements, and where they see the mutual interest of the continued viability of the tenant and both parties making it to the other side of this pandemic. But negotiating what is a fair proportion of rent is going to involve different commercial imperatives to negotiating a new lease transaction. And so we can equally ask the question whether going forward those negotiations should also be carried out adopting a fair approach. The ADLS lease, for example, is structured and well known as a balanced document from the landlord and the tenant's perspective. And as such, it does seek to adopt a fair approach. Now, as we know, the government has implored the parties, even to commercial leases, to be kind. However, a lease is a commercial arrangement, and with any commercial arrangement, the parties will generally seek, if they have the bargaining position to do so, a set of terms that are most favourable to them. As mentioned, the government looked at applying a mandatory rent abatement regime into leases, but this would have cut across the commercial terms that had been agreed. And although everyone has their own view as to whether it is right or wrong to legislate for rent abatements when none otherwise existed, Winston Peters, for one, would not support this measure for the reason that it ran roughshod over the sanctity of contract. But how to achieve a mutually beneficial outcome? it is mutually beneficial for the parties that they don't end up in a dispute and that their money is spent on rent and mortgage rather than resolving legal disputes. So generally speaking, when it comes to drafting, you sacrifice certainty over flexibility. For example, use of words such as reasonable or fair proportion allow flexibility to provide for a myriad of scenarios that can't be known at the time the lease is drafted. And we've certainly seen that with clause 27.5. However, if what the parties want is certainty, then they can have that. But generally speaking, that's going to be at the expense of flexibility. For example, putting some prescription around what is fair. At the time the ADLS lease was drafted, this revision, it was decided that a fair proportion would not be defined in the lease, for example, by prescribing percentages, because it was just not workable to have a precedent document do that. But I'm finding in new lease negotiations in our post-COVID environment that landlords and tenants are opting for certainty over flexibility. So let's look at some of those potential mechanisms. The abatement could be pegged to the availability of insurance. It could be a percentage based on the proportion to which the premises are used for non-people purpose, based on a reduction in revenue, based on a reduction to at least cover the landlord's costs, and perhaps could also be based on for retail, based on gross sales without a base rent involved. But although it's not possible to draft a one-size-fits-all, the parties to a specific lease transaction can tailor the arrangement that best suits them and negotiate upfront how the allocation of cost and liability will fall. Knowing the type of premises, the business being conducted, these types of formula are much easier to devise and the parties are much quicker to reach agreement on these matters during the course of negotiations. So that concludes my session, but I think we might have a little bit of time for Q&A.
Indeed we do, and thank you, Michelle. That was really interesting, particularly to get that international perspective of what different countries have looked at doing or currently doing or not doing, as it might be. Now, interestingly, this hasn't happened yet today, but we have had a question which is not really a question, without tying you to a legally binding answer. I wondered actually what you might advise someone in this situation, but noting that you are not bound. So it says, not really a question, but we had a tenant who we gave significant rent relief to because they were concerned about their business going under. They received significant government support through the wage subsidy. They sell boats. Subsequently, they sold 10 times more boats in 1 month than they'd expect to sell in the whole of winter. It's a bit of a kick in the guts as a landlord because we gave relief and abatement because of their concerns re-viability, and they've then had a boom post-lockdown. Now, can't be the only person in this situation, and just for the tape, you are not bound by your answer, but what might you recommend this individual or this organisation looks at when things like that happen? I mean, it couldn't be predicted, but...
Well, unfortunately for this landlord, hindsight is 2020. Unfortunately, 2020 has different meaning, but look, they've obviously committed themselves to that agreement. But if we had to turn back the clock, what we would have suggested to the landlord before they reached agreement on the abatement with the tenant to get some more information as to the tenant's position, to say, look, actually, let's just have an interim arrangement where perhaps you pay 50% of the rent, and then in 3 months' time, let's have a look at your accounts, get them audited, and then we'll see the real drop in your revenue. That would have been a better way to approach it. But unfortunately, if they have negotiated and reached agreement on that fair proportion, even though in hindsight it's not a fair proportion from the landlord's perspective, there's really nothing that the landlord can do in that situation now.
Yeah. Well, I hope that's useful to the anonymous submitter. I think so. And thank you for all your time this afternoon.
Pleasure.
It was a really interesting session. Thank you.
Pleasure.